this the Macarena?
Pobrecito, te duele tu espaldito. Necesitas un abogadito para ayudar a tu familia. Estamos contigo.
This is not Evan.
Pobrecito, por favor no te enojes conmigo. Por el mejor consejo que te digo. Vamos
some good
juntos por
auto
el
tune.
mejor objetivo.
Yeah.
Well, this looks good.
Quiero ver su caso ser su
Sounds like
mejor
Enrique.
amigo. Que me digas tus problemas para ayudarte con ganas, amigo.
Yeah, but those bar rolls are
Quiero ver
awesome.
su caso ser su
He is
mejor
good at
amigo.
something.
Que me digas tus problemas para ayudarte con ganas, amigo.
Anyone care to?
All right, everyone. That's our own Evan Garcia singing a song, and I don't know what he said, but it sounded authentic.
Pobrecito means poor little thing,
Poor little
Brad.
child. Poor little
Oh,
thing.
poor little baby.
They raised Brad speaking Australian. We were Spanish as kids.
What?
Yeah, Brad was only taught Australian as his foreign language when we were kids.
That's why
Yes.
he loves Outback Steakhouse so much.
That's right.
That's why I love bloomin' onions.
They're good.
Welcome, everybody, to this morning's episode of the Justice Team podcast. We have an exclusive Justice Team panel today because we're going to talk about a subject that I think Bob rolls around the state in and gives seminars on. It's a subject for
It's an
a lot
alcohol abuse one.
MCLE for substance abuse.
Cheers to that.
So it's this deals a lot with pre-trial evidence and definitely in-trial evidence, and it's an issue that a lot of people get confused on when trying to line up experts or retain experts, non-retain experts. What can they talk about? What they can't talk about, and then we'll even get into how this looks on appeal and what can get overturned, excluded, admitted, etc. But before we begin, let's talk about these cocktails that Mr. Marat de Behan whipped up for us this morning. What do we got, Marat?
So this cocktail I just invented right on the spot.
What?
Yeah, true story. So it's a third of a glass of ice. Key to this cocktail: third of a glass ice, vodka, preferably French, but we're not going to name names since we don't have an official sponsor. OJ, dash of club soda, and a splash of cranberry. But we don't have a name for this cocktail yet. So if anyone's got any
So
suggestions,
viewers out there, if you want to take a guess or I guess name this cocktail,
name this
The
original
CFO.
cocktail
name
that was
this
just
completely
invented.
original cocktail, never been drunk
Groundbreaking.
before.
First time anyone's ever had this combination.
We are going to talk about the case called People vs. Sanchez,
Good transition.
just like Bob did
that.
early in his life. Let's introduce the panel, starting with my far left. We got my twin brother, who
Hi.
just turned 40.
I
Congratulations. Happy birthday. I didn't get you anything. Maybe
I didn't get you anything either.
This is awkward.
It is. Shit, I forgot. Whatever. You're welcome. Hi. That's all I got.
Okay.
keep going.
Hi, Brandon Simon, the other brother, the better brother,
Best brother.
best brother.
Of course, me, Brad Simon. To my right, we have
Brooke Bove,
She does her appeals.
In-house
the
appeals.
nerdiest one.
Yeah.
We played Dungeons and Dragons
Yeah.
this week. In
Oh
an
yeah,
attic.
you're right. Yeah, you're right.
Yeah, so you're clearly the nerdiest one.
Did you play?
Did I play? No, I did not play Dungeons and Dragons. I have never played Dungeons and Dragons in my life. Did I just lose my nerd card?
Pretty much.
I think
Not
I
a life,
did.
not a life worth living.
Damn.
Yeah.
Is it too late at 42 to start?
No.
No, never too late.
Okay.
Never too late.
and last and certainly least,
Hi, I'm Sevy.
God.
Sevy Fisher.
So I wanted to give you a little bit of background on Sanchez. When I give these talks, I like to give a little bit of an overview because it's simply just evidence. I mean, it's what we
Right.
learned in law school. The problem is it was people were misapplying it. We had medical doctors up there for the defense, mostly just regurgitating things they read in medical records, and it was bananas. And the Court of Appeal finally decided to step down, but it's actually a criminal case. And there's a big misnomer that civil lawyers are like, well, it's a criminal case, doesn't apply. Come on, dummy. Brooke, does it apply?
It absolutely applies.
on, Tommy.
Evidence is evidence is evidence.
That's right. So People versus Sanchez was a criminal case, and it came to play because Sanchez was arrested, and there was 3 criminal charges essentially that went to trial on, and one of which was a gang enhancement trial, or a charge. And for gang enhancement, you had to prove that they were in a gang and in order to get the enhancement. So what the prosecution did in this case is instead of calling the police officers or the people that had actual knowledge of him being in a gang or him saying that he was in a gang, they called just one expert who went up there and took the stand and says, yeah, somebody told me he was in a gang, so yeah, he's in a gang. And they convicted him on a gang enhancement charge. So it went up in the Court of Appeal, and it's like, you can't really do that. I mean, the reason being is you had an expert up there talk about something that he heard, which is hearsay.
But Sevy, can't experts rely on hearsay, though? Isn't that the rule of evidence?
They can rely on hearsay, but they cannot regurgitate hearsay.
And they can't form their sole opinion.
Right. And there's a big difference in saying, like, hey, I reviewed all this information, and based on all this information and, maybe my examination of the plaintiff, this is my opinion. They can't say, well, I reviewed all this information, and, oh, guess what this information says? Dr. So-and-so said X, Y, Z. So big difference in that's something that they often confuse, even judges confuse. Relying on hearsay does not mean regurgitating hearsay.
So we got to almost educate the judges. And Brandon, we do you do a lot of motions in limine. Do you do any specifically on this case or a trial brief?
We do one specifically on medical record hearsay. I think even before Sanchez came out, we were filing this proactively because, like Bob said, for us that are up on the evidence code, it shouldn't have changed the way evidence was coming in. It just, I guess, made it more clear. It's still hearsay. It's always been hearsay, but there was a little bit more lax rules. The judges were kind of letting in hearsay without foundation because you can rely on hearsay. So they were kind of
a big catch-all that they still get it wrong.
Right. So we actively file motions in limine regarding Sanchez. We educate the judge. It's still. I feel like most judges now are getting it more now that Sanchez came out, right?
But there's still seminars on it. I've spoken at a few of them. But you understand, hearsay is an out-of-state court.
Out-of-court statement used to prove the truth of the matter asserted.
And you have to have an exception.
Or a non-hearsay exemption.
We had 2 years of this in law school to learn this very simple.
It's literally the first thing you learn in evidence.
Apparently the first thing forgotten in trial practice.
The biggest problem with it is that judges give, experts so much rope, and just let them do whatever they want. And they just think, oh, well, he can rely on it, therefore he can pretty much do whatever he wants. The problem, that's the problem, is you got to rein in those experts. Just because they're an expert doesn't mean they get to get up there and violate all the evidence.
Yeah, so I'm going to give you a perfect example. Stuff we see all the time in our cases is you have a radiology report or an MRI report. You have the defense doctor get up there and say, well, what did you rely on for your opinion? Well, I read the MRI report. And the MRI report says that it's a degenerative condition. Wait, objection, hearsay. And a lot of times judges would overrule it. Well, they relied on it. Whoa. So here's the problem. Did we get a chance to cross-examine or question the radiologist on his findings? We have another doctor up here saying his findings are based on the findings of someone else that never saw the scans themselves. I mean, obviously you can cross-examine him on it, but it was just garbage. This was going on for years. Well, your client has mesothelioma. Well, how do you know? Well, I saw in a medical record that someone else diagnosed him with it. Wait, what? So just a practical tip for everybody out there that is prepping your experts to make sure there's a fail-safe for them to be able to testify, because they can get excluded under Sanchez. Just have them say, based on my training, education, and experience, review the medical records, this is my opinion. That's okay.
Right.
Because you're not regurgitating hearsay. But if you start to just parrot, if it's just solely based on opinions of others, that's where you're going to run into a problem. Brandon's going to get you excluded.
And backing that up even more, it kind of dovetails into if, they do have to call that radiologist. Mm-hmm. And in that radiology report, it's all opinions. Mm-hmm. So dovetailing into that, if they say, well, we'll just call the radiologist to trial, make sure that radiologist is on the defense's 2034 designation, because if they're not, they can't give opinions at trial, and that's all that they do in that report. So they're excluded altogether if they're not on the 2034.
Where preemptively, I'm just thinking, do we preemptively, before you go to a trial, do you say, hey, here's a trial brief on Sanchez, or do you say, specifically in this case, we think the defense is going to try to get this into evidence, and we're not going to let them because they got a X, Y, like what Bob just went over. As a practical, strategic matter, do you do that on cases, or do you let them, like Sevy said, wait until trial and then they don't have them on the 2034 and it gets excluded?
I think you have to give the judge a heads up if they're specific.
Yeah.
I mean, I usually file.
They'll ask you.
Your motions in limine should come after their designation.
Yeah,
so
I usually file
won't
one,
tip them off.
a broad one. That's more like a pocket brief or like a trial brief, but I call it a motion to eliminate and basically. It's not really a proper motion to eliminate under the Kelly versus New West federal savings trial or case, because you're not actually identifying evidence. But I'll usually do that for the first crop of motions eliminate, and then once expert depots are being completed, actually put citations into a new motion eliminate saying he's specifically violating Sanchez here, 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 and here.
Right, so
they can't give that
I
opinion.
think it is
general and specific.
I think it is
Right.
proper as general because you're saying medical records. You're identifying all the evidence. There's a laundry
True.
list of medical records that you're identifying, and you're letting the judge know that. And making them specific, I think, is bad because then you're letting the defense know what you're afraid
And
of.
I'm going to give you a real one where we got a lot of excluded. We had a case recently that Sevy and I were trying, and we had a client that had years, tens, decades of medical treatment for a back condition, and the defense's position was, well, it was due to his pre-existing other car crashes he was in or he's hurt at work. So when I took the deposition, because we know Sanchez very well, I kept asking him to specifically identify what he's relying on that says that these are from prior incidences, and he couldn't name them. He couldn't name the date. He couldn't name the medical record, and we went to exclude, and the judge is like, well, he says he doesn't know. He was able to point, like, I said, how many times of prior medical pain or back pain did he have? He could point to 2 over 25 years. And I made him pull out the record, and I attached it. And the judge said, guess how many incidents of prior back pain he can talk about? 2.
Right.
Because the defense want to talk about like 50. And he's like, and guess what? You have to call the doctor to lay the foundation unless the plaintiff, you can get in through the plaintiff at any time. It's a fail-safe. Because the plaintiff is a person that's there to testify. They can talk about their prior pain, their medical
But they're
condition.
not going to remember.
If they're prepped correctly.
Exactly.
So, Brooke, how does this look on like an appellate level? You have a case goes like for the plaintiff goes south because the defense expert went up there and just said, "Well, this is what Dr. So and So diagnosed him with 2 years ago."
Well, make sure you don't waive Sanchez, right?
Right, yeah, that's the first thing. I'll make sure you're laying your objections.
Ah, 'cause we see that a
before
lot.
Trial,
Defense-
the best is the motion in limine. You've got it. The request and the entering. It's like entering a pre-objection before trial that you're going to object to it. And then at trial, don't miss your chance to object. And then after that, it becomes just a battle of case law. But
So what would be the standard if that happened
well,
and there's a defense verdict and of course the trial court doesn't grant a new trial?
so it's really important to try to get it right at trial because on appeal, it's a discussion of what evidence was admitted, and so the standard of care is abuse of discretion. Mm-hmm. So the Court of Appeal is always, when it's an evidence-related issue, is always going to say the standard of review is abuse of discretion. So you've got to prove not just that the court made a mistake, but that it abused its discretion in making the mistake because the court gets to use its discretion.
Yeah, it still has to be a prejudicial error as well,
Well,
right?
so that's the second tier.
yeah.
So if you can get to the level of proving that it's an abuse of discretion, then you've got to prove that, okay, so there's an error, but how did that actually prejudice?
So you better get a
plaintiff's
juror
case?
declaration saying,
You better.
I found
Yes,
we found this way because of this prior record
practical
that he
tips. And
referenced.
what can we do out there to perfect that? Because I could see Court of Appeals going, no harm, no foul.
Well, so a juror declaration is gold. If you can get a juror to say that in a declaration, it's really difficult.
what can you say in
Yeah,
it,
so in a juror declaration, can you just say this is what we talked about and this was what we found? Or
Well, you have to be really careful with juror declarations too, because then you're getting into more hearsay issues, right? You can't say, "I was in the jury room and I heard 2 people saying X, Y, Z, and and they were the holdouts, and that's why we didn't get the verdict." Because now you've only got a hearsay statement of what other jurors were saying. You have to say, "I participated in this discussion. This was the topic of conversation," and you have to make sure you phrase it in a way that's not this person said or X person
and not their
brought this
mental
up.
impressions.
How about
It's got to be.
we came down no on the substantial factor question because of the prior back pain
You gotta
that we heard
elaborate.
Because-
You gotta elaborate a little more on that.
Yeah, because we believed the defense expert when he was talking about the prior conditions or the prior issues, and we believed the defense expert. We found him more credible because he was giving all these facts about the past stuff. And the more specific you can be, the better.
I get a lot of questions from people. We're always on the listservs. People always ask, should I waive Sanchez? And we always tell them no.
Absolutely not.
No.
It's a big sword for the plaintiff's bar, but the reason
It's
that
evidence.
the reason a lot of people want to waive it is
Lazy.
it's short. It's not lazy. It's short sighted. They are afraid to have to pay all of these expenses to get these doctors
To lay the
into at trial to lay the foundation. And one of the tools that we use, that we always tell people to utilize, is the defense will always list every non-retained treating doctor under the sun. And when they do that, you are able to then take their deposition under videotape under a certain code section, and then you can play those videotape depositions at trial. So you're not having to call these experts, these doctors, to trial to lay the foundation. Yeah. You have them on videotape laying the foundation, so you can take a direct
exam. It's a big
exam.
misnomer, and a lot of people think that, actually, there's been studies that videotape depositions with the word scrolling at the bottom are more paid attention to by jurors today than actual live testimony. Thank our cell phones, right? But that's true. So we do a lot of videotape depositions, and you could do it in discovery. And by code, MDs are always unavailable. So you could play.
Well, non-retained MDs are unavailable.
Yeah.
The opposing expert isn't. But you can still. Well, if it's the opposing party's expert, you can still play it under that. They don't have to be unavailable. You're right.
So just from a foundation perspective, Sevy, how are ways our listeners can lay foundation so they don't get in issues with? I'm going to give you some examples. Your life care planner up there. Another example, having your medical doctor talk about all the treatment that your client had or specific instances that your client went through. What are some stuff that you do to lay the foundation for those experts?
Well, with life care planners, I think it's, this is always a topic of discussion, but I always make sure my life care planners are prepped from deposition to say, based on because they have a bunch of sources for their numbers, right? They're always giving numbers. They're giving reasonable and customary costs in the community, and they're giving those for past and future oftentimes. So what I have them make sure they say is like, look, yes, I go to these sources, I rely on these sources, but these are my independent opinions based on my X years in as an expert doing this stuff. Even if and if they really get pressed on it in deposition, so you wouldn't be able to give me an opinion on how much a single level lumbar L5S1 fusion is if you wouldn't have gone and looked at, healthcare, Fair Health online, correct? No, that's not true. I could give you something within, $10,000, give or take, what's reasonable and customary in the community. And that's appropriate, because damages have to be reasonable. They don't have to be exact. They have to be reasonable and customary in the community.
What about life care planners that call, providers and ask them, what's the cash rate or whatever? What do you guys charge for XYZ? Then you're dealing with another level of hearsay, right? You're relying on something somebody else told you to put into your report.
Right. And, oftentimes I've seen it go both ways. I've seen it, these life care planners do that too. And if it's my life care planner, I tell them, you did that to confirm what you already knew.
Exactly.
But if it's their life care planners, I said, well, that cost specifically came from that facility. And that facility, we had an expert that flew in from Phoenix one time, and he didn't know the reasonable and customary costs in the community. He had to call these people up, and he got excluded from saying that because he didn't know.
And there's a difference, and Sanchez talks about it, the difference between case-specific hearsay and non-case-specific hearsay.
Yes, exactly.
So
what does that
Yeah,
tell us about that.
Tell us what that means? Because I don't know.
Right. So case-specific.
I know. I just want to hear you say it.
Non-case-specific hearsay is what you're talking about. Like that's the books that you're reading, the training that you're getting as an expert, all the CLE classes we take. That's stuff that we're learning about the law. That makes us experts. That's non-case specific. Mm-hmm. It's general. It applies to lots of different situations.
It exists in the universe without the case.
No matter what, if this case didn't exist, you would still have that knowledge and you would still have that information that came from other sources.
And that's okay.
And that's fine. That's great. Case specific hearsay is stuff that is directly and specifically only related to this case. It's the facts, it's the comments, it's the testimony, it's the it's the experiences of just the parties in the case.
Yeah, so you could make that argument that even calling those people and getting those prices is not necessarily case specific. You could say, well, look, this is what they charge everybody. It's not necessarily just specific to this case.
Yeah, and for life care planning specifically, because we deal with a lot of this in our bar, is those coding sources, American Health and the American Hospital Directory, they exist. That's not case-specific hearsay. That exists in the universe. It's available to all parties. And sometimes, like, the defense or other people try to confuse that. But that's not what the Sanchez deals with. We're dealing with, and let's do some, like, specific examples. Like, in this case, my life care planner is giving opinions on the cost of future medical care based on the recommendation of somebody else. That recommendation of somebody else is case-specific hearsay. It's determined on the case-specific facts. So, Sevy, how do we lay the foundation for that?
Well, your doctor's going to testify to that, first of all.
Yeah,
right?
once it's in evidence, it's not
no
hearsay.
longer hearsay.
Yeah.
So your doctor made those recommendations as their own opinions. And I guess if they want to be really technical and your life care planner has to go out of order.
Well, actually, the Sanchez actually says specifically, and if you read the case, I think everybody should.
I'm sure Bob read the case.
I did. Not. I had somebody else read it to me and tell me what it said. But it actually says as long as it's reasonably certain to come into evidence.
Right.
So you can take it out of order. However, I always put this on the judge's radar, and I tell them, look, if you're gonna let this expert testify about it, and the defense doesn't call that person to lay the foundation, it's excluded, right, Judge?
Right.
Yes. And the judge will tell the jury, and I've had it happen. Excluded. That opinion they gave, gone.
I have a question because we had a colleague run into this recently against the notorious defense attorney. You brought up MRI reports. What about MRI films?
Oh my God, this fear infuriates me. MRI films.
Bob angry.
I'm angry. MRI films are not an opinion. It's like looking at a photograph. It's not an opinion about a photograph.
Right.
It's self-authenticating.
Yeah, because what's the first prong of a hearsay? It's got to be an out-of-court statement.
Yeah, it's an
picture's not a
electronic
statement.
prontout.
It's 1,000 words.
Right.
Yeah. So it's somebody's opinion based on the read. That is a Sanchez issue.
But it's still, there's a difference between
got that question
There's a difference
yesterday.
between authenticity and foundation,
Right.
right?
Well, yeah, okay, I'm 100% okay. Oh, yeah, I'll stip to authenticity. That's fine.
Sure.
Right.
That's why it's so important to get a good judge.
What
And-
about when
Those
you
are-
have like Sevy, we've got you need an accident reconstruction, or you have like someone going out to do an inspection, a site inspection. What kind of Sanchez violations or Sanchez things should you be careful of when your expert or somebody else is going to do that?
Measurements, things like that, out at site inspections, things like that. Oftentimes, these senior engineers will send their junior engineers to do that, and then these senior engineers are the ones who you've retained. So be careful with that. If it's a big, large case, I make sure that senior engineer is out at that site inspection. If it's maybe a smaller case and they let the junior one go out there, I mean, just
I list them all.
You don't have to, but list them. List the junior engineers as non-retained, or I guess
That's
technically
retained.
they are retained.
Because you can still get a stipulation,
Right.
a narrow stipulation, like
Right.
we can stipulate to the measurements. But on that, Brad, so whenever we're dealing, if you look at the police report, that's all case-specific hearsay. If you're trying to get in measurements from the cops at the scene or things they saw, you need the officers to do
Right.
that.
And just a practice tip, like in the real world, obviously everybody disagrees about what this says, and what the holding in Sanchez means is whatever your judge says it means. So, what I like to do, and I did this in a trial, a very big case, the defense attorney, before my accident recon got up there, he goes, well, what are we going to do about Sanchez? Like, are we waiving Sanchez, or are we going into... I go, look, we're not waiving Sanchez, but my expert's going first. I'm going to direct him. Watch what I do. Don't give me shit, and I won't give you shit. And that's exactly what I said to him, because look, they can make our lives miserable on certain things if they really want to. If the judge doesn't understand Sanchez, which most of them, a great majority of them don't, and we can make their life miserable. You want to have a trial? Just watch what I do, because we go first. And if you object a bunch and it's just frivolous stuff, then I'm going to do the same to you. So
I mean, and there's a point. I mean, sometimes it's stuff like if there's stuff in the medical records are false and like taken
Right.
out of context, and the defense is trying to get it in, don't stip to medical records. Actually, I never would do. But I had one lawyer fighting me on the damn speed limit where the accident happened on a liability dispute. I had to call
The same one who objected to the
MRI.
hearsay on the MRI film.
Yeah, and then another case, he had the complete opposite position. Well, whatever. I had to bring in a city engineer to talk about the darn speed limit. I mean,
There was a sign.
The judge was mad at him too. Yeah. There was a sign out there. It was so silly, but it was a recoverable cost.
What
Got that
about
back?
I have a lot of questions because I don't know the answer to this. Does Sanchez apply on cross exam?
Yes. And that's a big misnomer, and it says it in Sanchez. A lot of times they say, well, you could do anything in cross. You can cross on the records. No, you cannot. If you're using case-specific stuff out of the medical records, again, it has to be reasonably certain to come in through the trial. And I think that's one big thing we put into
So
our
you're
briefs.
saying like the defense attorney can't say, well, on April 19th, 2017, Dr. Patel said this, didn't he, to their expert?
Can't do that.
Okay.
And some judges read that incorrectly, but if you actually read the case, it says completely opposite. And what I do is I object, I preserve my objections, and then I go up on redirect, and I hold up a blank piece of paper. I say, well, you understand the lawyers can say anything, right? The judge read that jury instruction. They'll be like, well, yeah. And I was like, well, let me read you this. Isn't it true that Dr. Patel says it was all traumatic related and da-da-da-da-da? And they go, objection. I say, well, see? we could say anything we want. Then I go in closing and say, these medical records aren't even evidence. These people are just making stuff up, and it looks desperate.
You got to prepare for all of it. I think at the end of the day, before trial,
Prepare like it's coming in.
I prepare like everything's coming in. And knowing the medical records, and oftentimes that stuff's taken out of context. So I think you prepare for it to come in, and prepare for how you will deal with that coming in. I think that's always for all trials. We just act as though it's coming in. So.
And who is the one person at trial that can get in most everything for you?
Plaintiff.
Your client can pass medical treatment they went through, things they saw and observed. It's not hearsay.
And what's your advice if the defense
This isn't
attorney
my
asks-
advice, but I'm just saying, like, if you did this, it's very good lawyering. If you told your client, if I'm showing you something on the stand, you remember it, that's your signature, that's accurate. If anybody else does, you have no memory, that's not true. Can't get it in. And if that happens,
we went over the records with them.
not we. I'm just saying I heard somebody that does this. That's probably really good at doing it.
The royal we.
The royal we.
That's a good idea.
Bob, how about prior similar occurrences? How does that weave into the Sanchez?
So prior similar occurrences, if you're doing a premises case, it's used for a different purpose. So always look for exceptions. So that can go to notice. There's all kind of different creative ways to get
If you're
around
not
that.
using it to
Control.
prove the truth of the matter asserted, it's not hearsay.
Look, and don't be too. I put up a list of all the evidence code and exceptions. They're on the counsel table with me at all times. Some people think they have to memorize everything, and you probably should. But if you don't, just have a list there.
No, I always say being a lawyer is knowing where to look for the information that you need all the time. Nobody can have it all
Brooke,
in your
how
head.
often are you doing an appeal and it frustrates you to no end the trial counsel's not preserving the record and not objecting?
Every time. That's the worst. And it will sink your appeal. It makes you have nothing to stand on.
I mean, there's a case that says if you don't preserve the objection at the time, you're done.
Yeah, you have to lay that
When you
foundation
object,
because the court's going to say well, nice that some other appellate attorney came in after the fact and saw what should have been done, but that didn't help your client at the time. This could have prevented all this work.
Yeah.
When you object, would you say just objection Sanchez, objection hearsay?
Objection hearsay.
Just have
Sanchez.
Steve Fleshman argue your MILs for you.
I saw him yesterday, by the way. But I mean, it's true. And I'll do speaking objections sometimes. Because the jury, I had a jury. There's one case called Kennemer. For our listeners that don't know that, it means that when an expert gives their opinions at the time of depositions, that's what they're locked into. They can't go into new subjects. So I had one trial, and I was getting completely new opinions. The judge was inept, and I kept objecting. Kennemer, new opinion, objection, Kennemer, and I kept getting overruled. And one of the jurors came up afterwards, after they defensed me, and said, "What's Kennemer?" And I had to explain it to her. But we appealed and won the appeal. It was a dead bang. There was five things. The first one was those were all new opinions. They were clearly prejudiced. We got juror declarations because we have a good appellate lawyer, Brooke, told us what to do. But I had to preserve all of those exact objections every single time it happened.
So it sounds like when you do your expert designation, you just want to list everyone as non-retained, right, Sevy, just in case you want to get it into evidence later.
No, you don't.
Ooh, trick question.
You want to make sure. That's why you need to go through your medical records beforehand and list everybody who helps you. Never list a radiologist ever unless their report, which they rarely do because radiologists aren't really trained to say, oh, well, this is a traumatic. I see a traumatic finding at L5S1, or I see a traumatic finding at C45.
They might, but you got to talk to them first.
Yeah, talk to them.
Yeah. So, if they will testify and they can say that based on looking at the MRI alone, then yeah, list them. But you got to do your homework before you do your designation. That's for sure.
Chiropractors will kill you. Don't list chiropractors non-retained because they always have pain diagrams.
They're diagnosing people with radiculopathy, bro.
Yeah.
Bro.
Because you don't want them to take the defense to take their deposition and say, well, they're your expert.
Right.
They listed you.
And just remember, practically speaking, jurors are going to trust a treating doctor 100 times over any retained gun. Yeah. So I always think
how
they win your
important
case
is it to, I guess, when you're doing expert discovery, do we affirmatively notice those depositions, or do you wait to the defense and then join them?
Depends.
What's the best way to do that?
Depends
on if they help you. 9 times out of 10, the defense will list non-retains that will help you. And
9 times out of 10, they're gonna take every single non-retained expert depo because they don't really care about the costs on the case.
What's the one case? So we got this the other day. The attorney says, you listed 24 non-retains. Please list everyone you plan to call at trial. Isn't there a case that says,
no,
sorry, bro?
Yeah.
Do you remember it?
The case?
Yeah.
What, cumulative experts?
Yeah, well, the one that says if we're non-retained, you don't have to tell them the ones that you're calling.
Oh, yeah, I don't know the name off the top of my head.
I knew it. He failed. Epic fail. But anyways, like, you don't know who you're going to call, and I think we're using
Guess
Sanchez.
who's writing your motions eliminate from now on?
Not
Not
you.
me. Have fun with that.
But what you got to use Sanchez for the judge. Say, Your Honor, we have to lay the foundation. You can't. You get a
Right.
cumulative one, but it can't be cumulative because you have to lay the foundation for it. So it's another free shot to be able to get what that doctor thinks during the course and scope of their treatment, because your doctor has to, your expert has to rely on it at the end. So I like to do it affirmatively if we can. Sometimes in discovery, because you could still do it in discovery because you can't take the chance that the other side's going to list them as a non-retained. But sometimes we're coming into trial after the expert designation already happened. So die be cast.
So for our listeners, Bob, do you have any parting words of advice of how to use Sanchez?
Okay, I do.
Okay.
But I'll wait till episode 2. No, just kidding. So I think it's very important, and Brooke runs one of our lit teams and our appellate division, is you have to affirmatively look at all of your medical records and see who helps you.
Right.
And if you talk to them ahead of time, and then if you list them as a non-retained, that's how you win a lot of these cases. And I think you have to be overly cautious whenever you're designating to list all those that help you and all those ones that help you prove a fact in trial. I talk to my experts, like for accident recons, hey, did you actually go to the scene? Or hey, who did the video analysis? Who did the animation? Because you have to list them on your designation, or you're struck. There's another thing that's a non-self, in my opinion, self-authenticating electronic data that you need a specialist to do, and that's the black box.
Right.
So a black box, you need to have a special certificate to be able to download it and analyze it. So Brandon's shaking his head no, but I think the answer...
What?
Yeah, don't. I know it. Stop it. I actually think that whoever downloads that black box has to be listed as an expert, because nobody else can rely on their... It's an interpretation, even though it's a printout.
computer.
It's not a computer.
101110.
Well, can you...
Authenticated.
Why don't you go download it then,
65
Brandon?
miles an hour. Crash. Delta
Oh,
V
my
100.
God. It's another guy.
Yeah. And public places, you can always just have your, we had a case recently, really good expert, senior guy, and one of his junior guys went out to the scene.
He's a safety expert?
I think it was before we got on board. No, not that one. He's also great.
Would you give him an A?
But
Okay.
But went out to a local Hooters, and the senior guy actually went out there. I just said, look, to avoid any Sanchez issues, since your junior guy went out there and did all the measurements, just go out there, have a beer and some naked spicy wings, and just confirm his measurements while you're out there.
Order
And
us some
Sevy
dirty
was there
Sanchez.
too.
And he's like, okay. So we had a lot of.
You were there too,
So we had some naked
Was it
wings
in
and
San-
curly fries with cheese on them.
Is it in San Diego?
So good.
Did you go to that Hooters in San Diego?
No, Hollywood.
We have
sure
a
you
case
did.
coming up with that one.
Yeah, my advice would be just don't ever waive Sanchez. If it's, I'm shocked at the amount of people that ask that question on the listserv, or why wouldn't I do it? I get just to bring in all these medical records without authentication. Well, yeah, dummy, because they're gonna just take things out of context and cherry pick.
Well, and
you had neck pain once in 2002. It's like, yeah, someone punched me and I went away the next day.
and the best way to do it, what I like to do,
Is that what happened to you? Is that why?
I like to tell.
I always wonder what happened to you in 2002, bro.
I ran into a basketball pool, teeth first.
Two
That
things.
wasn't Dad?
What? No, it was me.
No, he
I thought
pushed.
Dad spanked you.
Dad pushed me.
Oh, yeah.
No, two things though, as a practice tip. If defense ever comes up to you and says, "Hey, are we waiving Sanchez?" Ask them what that means to them.
Oh, yeah.
That's always great to hear. And then two is if challenge. Just say, "Look, I can't just waive all medical records coming to Sanchez on all medical records. Send me the ones you want in. I'll probably agree." And then they'll
Oh,
send
he
you
actually does this in front of judges to challenge him, and it's really entertaining.
Yes, and judges are always like,
Tell
sounds
him.
pretty reasonable. We've got thousands of medical. I'm not going to comb through all of them and just tell you I'll waive Sanchez, but and
Sevy's getting a free preview of what their cross is going to
exactly,
be. They have to do
exactly.
it.
And the judges are going to
that's
be like,
good.
counsel. It's either you haul in 30 custodians of records or give Mr. Fisher what you want, and he'll probably agree to it. Yes, Your Honor, we're reasonable.
And you ain't agreeing to that, are you?
Yeah.
You sneaky.
I do one quick
Never
question.
saw
I think
this
we're running
prior
out of time,
back
but what about in terms of medical bills? Does that
Medical bills.
is that case specific hearsay, like a medical?
I
know there's other foundational
Medical
issues
bills
with that.
are case-specific hearsay. However, medical bills themselves are not evidence. You could look at the Bermudez case, the Ochoa case. So I never admit medical bills and evidence. It's just what is the reasonable customary cost in the community based on what?
your knowledge, experience, training.
Thank you very much. And then you're good.
So you don't say like, "Hey, you have this bill. How much was it? Was it reasonable?" You can't do that.
that's not
How about
gonna
you just
fly.
say, "Okay, in your experience,
You can get
training,
stipulations,
what's
though.
your what is the reasonable customary value of a neck fusion global?"
$2 million.
And then you just you hit that other prong of Hal and the progeny by asking your client approximately how much do you owe for all your medical treatment.
Yeah, they know approximately.
They do.
How much was paid?
They
Things
have
like
a good
this.
estimate.
Yeah. Brooke, any parting words from the appellate division?
Well, I mean, whenever you're just kind of confused or not sure how it applies, I mean, just take it back to the law school level. Take it back to the basics. What is evidence, and what's hearsay, and is the thing that you're trying to exclude or object to, is it a case specific fact? Just go back to the basics of the case and synthesize out what it's going to be. Just
Are you
keep it
able to
basic.
prove or disprove that fact with the witness that's on the stand?
Right, and if the witness on the stand is the only source of that fact, then it's hearsay, and the expert cannot rely on it.
I have one quick thing before we go. We have to talk about this is when the defense says and the judge says, "Well, it's a business record exception from the medical records."
Oh, yeah.
My
I
God,
mean,
that's terrible.
Brandon already said it. Authentication.
Yeah.
That's a business record exception authenticates the document.
That's it.
But it does not mean that the information in the document is
Nurse
not hearsay.
practitioner.
Yeah, it does.
Assistant
What,
MD.
Like an event.
All this crazy.
That's it. There's like 3 specific things that you get into the business record, not the opinion of somebody else.
Right.
And that's
Right.
that's a big issue. So a lot of judges get that wrong.
A lot of it. I mean, I'd say the majority of attorneys don't understand that.
I think
Like
that's
an
probably
overwhelming
true.
majority of attorneys don't understand what the business records exception is.
There's 4 in this room. What? I was just counting.
1, 2, 3, not it.
Oh man, I guess I'm it.
Sorry, I had to vent about that one. That is just ugh.
It's a business record exception.
So what comes in a business records exception?
You still have to lay the foundation for what's contained within the document.
What's contained? So it's like an act, event, or condition.
Like
It's
this event happened on this date.
correct, because you can get into the plaintiff. You can ask those questions. Like that is a business record exception. They were here on this date, and usually if there's something in quotes from the plaintiff, you're going
Right.
to be able to get that in. 'cause
More
it
often
came
than
from
not,
them.
that's going to be the main stuff that comes in as complaints or statements from the plaintiff
Or
within those
opinions.
medical records.
not opinions.
Right.
Not opinions, right? Because a lot of that stuff can be copy and pasted, even like from ambulance records.
Any
or
Kaiser
whatever.
record.
Yeah.
They just list like 50 different diagnoses that may have ever happened in this.
I've been
person's
175 pounds for 20 years. It's been copy and pasted into all of my documents.
Man, that's amazing.
Sevy, any parting words before we get out of here?
Yeah, I would just say you have to, with Sanchez issues, you got to be able to adapt. No one's ever going to get it right. No one's ever going to get it the way you understand it. If they do, you're in great shape. But you just got to be able to adapt at trial and do your best and prepare for the worst.
Excellent. Well, that's our education seminar on the Sanchez case for Bob, Brandon, Brad, Brooke, Sevy, and Murat. I'm Brad Simon. Remember, there's no sleep till justice. Take us out, Timmy.
Pobrecito, te duele tu espaldito. Necesitas un abogadito para ayudar a tu familia. Estamos contigo, pobrecito. Por favor, no te enojes conmigo por el mejor consejo que te digo. Vamos juntos por el mejor objetivo. Quiero ver su caso, ser su mejor amigo. Que me digas tus problemas para ayudarte con ganas, amigo. Quiero ver su caso, ser su mejor amigo. Que me digas tus problemas para ayudarte con ganas, amigo. Pasito a pasito, suave suavecito, no vamos gritando, no más habladito. Dime tus problemas, quítate las penas y yo tomo su caso con delicadeza. Oye.